Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Leanne Lyon, and today we're focusing on trade secret protection and non-compete enforcement, two areas where prevention and strategy matter just as much as courtroom skill. Bob, what kind of information typically qualify as trade secrets under Texas law?
Well, a trade secret is something that is not generally known, and usually has been developed at some considerable investment of time and expense by the business, and it provides the business with a competitive advantage. Sort of the paradigm of a trade secret is the formula for Coke. That's not protected by any other form of intellectual property. It's just a trade secret, and it derives its value from the fact that it is secret, and it has a unique flavor that Coke would say provides it with a competitive advantage.
For sure. I guess Colonel Sanders would be another good example, I'm guessing, with their herbs and spices.
Yep.
Excellent. Well, what is the most common ways that companies unintentionally put their trade secrets at risk?
Well, generally it is not policing what their employees are doing with information that they want to keep secret. Employees all have a common law duty to keep their employer's confidential information confidential. And let me just digress a minute there. There's a difference between confidential information and trade secrets. The confidential information is anything that the company that's not generally known, not public knowledge, and that the company wants to keep confidential. A lot of financial information would fall into that. Profit margins, cost of goods sold, things like that. Trade secrets, though, not only require that they be secret or not generally known, but also that that the company derives a competitive advantage from them, which is not necessarily the case with confidential information. So employees have a common law duty. A lot of companies will have employees sign an employment agreement or a non-disclosure agreement, an agreement that sets forth the employee's obligation to keep things confidential. But particularly, in the days of remote work, employees can access the company's servers remotely. They can download stuff to their laptop hard drives, even, either a company issued one or a personal computer, a computer that they own. And if that's not regulated or restricted, then you run the risk that, employees will, collect a whole bunch of your confidential information or trade secrets. And when they leave, take it with them. It's also hard to, the forensics of it make the proof a little difficult, right? Because, typically, you've got an employee working remotely. They get fired. They're told to return their computer to the company, and maybe they wait. It's like 2 or 3 weeks later that the computer comes back, and it's obvious that a bunch of stuff's been deleted from it. So then, you can, forensically determine what's been deleted, usually. But then the question is, how do you prove that the employee retained copies of it or moved copies of it? So there's a forensic challenge in terms of the proof.
So how do you prove that information was actually misappropriated and not simply based on, say, an employee's general knowledge or experience. Total different.
Well, so you can't, with a non-compete, you can't prevent an employee from using their general knowledge and experience. Um, you can prevent them from using your confidential information, but then the question is, how do you prove that? And, one of the things that you're going to need to do uh, for departing employees is to image their computers as soon as they come back. If it's somebody that you suspect of having done something, you're going to need to have a digital forensic expert, review it and generate logs of what's been deleted and if there have been external devices connected to that computer, that can give you evidence that, because if the employee's been connecting, and say in the days before they return the computer, they've been connecting external hard drives or thumb drives to the computer, that's a pretty good sign that they're copying stuff over. And I think many times you can determine actually what has been copied through the digital forensics expert. So you've got that step that you can prove. If it's you may very well need to get a court order to give you access to the former employees' uh, devices, phones, tablets, computers. Um, but you've got to have at least some evidence that would justify you in making. That's a pretty intrusive thing to do, to take somebody's computer and let their litigation opponent search through it. And the courts are reluctant, and they'll put guardrails on that, some protections, uh, parameters, limitations about what can be searched for. So, nowadays it's a lot of it is digital forensics.
Yeah, I can imagine. But non-compete agreements do get a lot of attention. What does Texas law currently require for a non-compete to be enforceable?
Well, number one, it has to be, and this is language from the statute, ancillary to an otherwise enforceable agreement. And let me explain what that means. Because there's a fair amount of Texas case law that deals with that concept. Um, Most employment relationships in Texas, probably across the country, are at will relationships. In other words, either party can terminate the relationship without notice and for any reason or no reason. So what the courts have determined, probably now a couple of decades ago, was, well, if you have an at-will employee and you make them sign a non-compete, they're not getting anything for that non-compete because they don't have any guarantee that they're going to be employed for any, a minute after they sign the document. So there's what you call a lack of consideration for that. So the way most employers address that is they put in either you can have an employment that has a term of years. We're employing you for 3 years at X salary, and we can't fire you unless we have good cause to fire you. Or they will put in obligations on themselves to provide the employee with training and access to confidential information that they'll need to use in the performance of their job duties. And those promises are generally sufficient to provide consideration for the employee's agreement not to compete. So, once you get past that hurdle, then the terms of the non-compete have to be reasonable in terms of duration, geographic scope, and basically subject matter. What so you can't work for another dentist's office within 10 miles of your former office for 2 years. And In terms of time durations, um, 1 to 2 years is usually found to be reasonable. Um, Geographic scope depends a lot on the nature of the employee's job. Um, for people involved in uh, nationwide businesses, the chief marketing officer for a company that has operations in all 50 states, you know, a geographic limitation of the United States may very well turn out to be reasonable. And then in terms of subject matter, it's, you can't stop people from working entirely. So it has to be, reasonably tailored to address um, the business's legitimate concerns about being, unfairly competed against. In terms of, say you bring an employee in, they learn how you market, they learn, who your best customers are, they learn uh, your plans for the future, and then they go to a competitor and they use all that knowledge against you. That's what businesses are trying to avoid.
Right. When disputes do come up, what factors tend to influence whether a court will issue an injunction to stop a former employee or competitor from using certain information?
I guess there's really kind of two things there. One is in terms of non-competes, because generally the purpose of a non-compete is to keep a former employee from using confidential stuff that they learned while working for you to compete against you and take business away from you. That's sort of the general idea. So there's, the non-compete itself. And for a court to enforce the non-competes, a lot of times what the courts are looking at or looking for to give an injunction is there some evidence that the employee actually is using or disclosing confidential information and using it against you, using it to take business away from you, using it, to go after your customers. So that's certainly one element. The other, another factor is, do you actually have evidence that that's happening? I mean, simply the fact that somebody goes to work for a competitor in a similar position to the one they had at your company, doesn't necessarily mean that they're, doing anything that they're not entitled to do. Um, so, if you've, I mean, if the ideal is you catch the employee red-handed stealing your confidential stuff, um, and at that point, I think the court's general sympathies probably lie more with the employee than with the employer in these situations. But if the employee is doing something clearly wrong, um, then that shifts the balance of sympathies and makes an injunction more likely.
Well, for employers, what practical steps make the biggest difference in preventing these issues before they ever reach the courtroom?
Well, number one, you need to have somebody who's familiar with this area of the law, review or preferably draft your employment agreements so that they don't run afoul of the reasonable limitations, and really give some careful thought to uh, how long, the geographic area, and the subject matter, because uh, the Texas statute does provide former employees with a potential counterclaim if the restrictions are unreasonable and the employer knew they were unreasonable and was imposing them or trying to enforce them for something other than a legitimate business purpose. In other words, just to punish the employee. So in that case, the employee can have a counterclaim to recover their attorney's fees from the employer. So, you want to look at that. Again, when you have a departing employee and they've had a computer, you need to image it. You need to have it have a digital forensics person go through it, analyze it to see if there's suspicious activity that's present on the computer. I think training issues. Sometimes one of the things that employers have to do is they have to take reasonable steps to keep their information confidential. And I talked about this a little bit before, but if you have basically an open architecture where any employee can get into any company information, that you may lose the protection of that stuff because not every employee has the need to have access to everything. So compartmentalizing and restricted access goes a long way, I think, to convincing courts that you're really treating this stuff seriously. I think training employees on what's confidential, because
Yeah.
truthfully, the confidentiality provisions that are in most employment agreements are just so broad that it just lists every conceivable type of information, customer lists, supplier lists, financials. It goes on for a paragraph that's probably 20 lines long with different kinds of things that are considered trade secrets, where you know you can't really plausibly contend that every single piece of paper and every electronic file in your company is a trade secret or confidential.
Well, as we're wrapping up, how should businesses handle situations where they're hiring somebody from a competitor? Because we know that happens, and on LinkedIn makes it easy to make that happen. But you want to avoid stepping into a non-compete or a trade secret claim.
Well, that needs to be part of the interview process.
There you go.
You need to find out if the employee does have a non-compete. Um, you need to get a copy of it, and you need to get an undertaking from the employee that they're not taking anything with them.
Right.
Um, you know, and that's really in the employee's interest as well, because if their presence at a competitor is going to generate a lawsuit, they will very likely will find themselves out of a job pretty quickly. Um, particularly if they've not been candid with their new employer about what restrictions were on them, or you know um, what sort of information from the old company they have retained, if anything.
If they don't have a non-compete, are they free and clear in that case?
No, I mean that's a big step, because the non-competes, um, sort of one of the reasons for a non-compete that is the idea that this person has been so exposed to so much of our confidential information and the way we do business that
Mhm.
it's going to be damaging to us. It's going to be inevitable that he uses this information against us. So we need to have the non-compete to guard against that. And because it's so hard to prove that somebody's actually using your confidential stuff against you. So, but as I said, even companies that don't require non-competes will have non-disclosure agreements or confidentiality agreements with employees. And even if they don't, employees do have an obligation, even after they left their employer, to not use or disclose the employer's confidential information. So if somebody, takes away a hard drive with, you know, 25 megabytes of, or a gigabyte of documents from their former employer, that's not good.
No. Well, finally, for executives or counsel evaluating whether to bring or defend a trade secret or non-compete case, what key questions should they ask before moving forward?
Well, okay, a couple of things. First, what information do you have that suggests that the employee is actually either competing with you or has taken your confidential information? Um, if you've got some good evidence there, that's a that's that would counsel in favor of pursuing it. The second strategic question is going to be, what are your goals for bringing this action? Um, Generally speaking, most employees, former employees, are not going to be able to pay a big judgment of money damages. So you're going to spend at a minimum several $100,000 pursuing this non-compete case. And at the end of the day, is it going to be worth it for you? Now, if you can bring in the new employer on a tortious interference claim, then potentially you've got a deep pocket that could be answerable for money damages. And then the other issue is it may be necessary, it may be worth the money to show your other employees and former employees that you actually are enforcing these, because otherwise they'll just run rampant, thinking that okay, I signed that, but it doesn't mean anything because they're not going to do anything about it. So that's also a consideration, is the impact that it'll have on deterring other people from engaging in that same sort of activity. And then the other factor is how much damage is this former employee likely to do to your customer base or your business if they are allowed to continue to be employed where they are. In a lot of industries, it's you will be hard pressed to prove that in terms of damages that, because they left, my revenue from this business segment went down. Well, that could have a lot of causes. Now, on the other hand, if some of your longtime customers immediately stop doing business with you and move their business over to the new employee, that's a pretty good indication that it did hurt your business, and it may be something worth pursuing.
Well, as always, great information, Bob. And that is it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Robert and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thanks for listening, and remember to like, subscribe to the show, and share this episode with somebody else who might need it. Thank you, Bob.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.